The misadventures of the East India Company had made it very unpopular in Britain. Its barbaric wars, unscrupulous corruption, and Himalayan financial crisis had become the talk of the town in London. The political elites were aghast at what EIC was doing. Its rivals were jealous, and common people were shocked at the state of affairs in India. And therefore, there was tremendous pressure on the British government and the parliament to closely regulate what EIC was up to in India. And therefore, we will see that with Regulating Act of 1773, a series of acts will start which will try to have stronger and more effective control of the British Parliament on EIC's functioning in India. With every subsequent act, the control of British Parliament and government will become more and more comprehensive on the East India Company. And this will be like a countdown to the end of EIC's rule towards the mid-19th century. Today in this series on modern Indian history, I, Jawwad Kazi, will be taking up the discussion on the series of acts passed before the Crown takes over. This is a crucial topic, dear students, from exam perspective, especially from prelims perspective. A lot of potential areas from which questions can be asked and definitely have been asked before. So let's dive in and get to see what were the provisions, context, and consequences of these acts. Broadly speaking, this is how EIC's rule is going to evolve over the course of several centuries. Starting in 1600, when it got the charter, when it was incorporated and got the charter, for the next century and a half or so, East India Company largely remains as a trading power. But around mid-18th century, when it was able to defeat the Nawab of Bengal at Battle of Plassey and later win Battle of Buxar, East India Company will go into a metamorphosis. East India Company will no more just be a trading power, it will be transformed into a political power which has control over large parts of Eastern India, Bengal, Bihar, and Orissa. This will inaugurate a period what is called as the dual government. 1765 to 1772 is the period where East India Company was having tremendous authority but no responsibility for governance in Bengal. This period will end into a big fiasco. East India Company and its officials will drain away the treasury of Murshidabad, making Bengal go through one of its worst famines ever. Clive, Watson, Warren Hastings, and many other company officials will become super rich at the end of it. But the company, surprisingly, will be on the brinks of a bankruptcy. When this will be known in London, the process of closer regulation of East India Company's affairs will start. And we will see that the period from 1772 to 1857 will have a series of acts passed by the British Parliament, which will try to closely regulate its affairs. Now we are going to start discussing each of these acts in terms of its context, content, and consequences. After Revolt of 1857, when the Crown takes over, there will again be a series of acts which are also important for the exam, but then we will discuss it in a subsequent lecture. Today, our focus is on this period, that is acts passed during the company's rule. So constitutional development of this period is what we are now going to discuss. What are the major acts that we must know about? Starting with Regulating Act in 1773, which gets the ball rolling, we start this process. We'll see how initial attempts will be made to regulate EIC's affairs in India. To overcome the limitations of this act, the next act, Pitt's India Act, was passed very soon. And then after that were followed a series of charter acts, 4 in all, 1793, 1813, 1833, and then lastly 1853. Each of these acts will progressively reduce the autonomy of East India Company and increase the control of British Parliament on the company here in India. This is going to be a constant trend that we will see. Increasing control of British Parliament and reducing scope of East India Company. Parallelly, apart from this one trend, the second trend will be centralization of power towards Calcutta. These three presidencies, Bombay, Madras, and Calcutta, these three initially largely acted, by themselves. It was only when wars, peace, and other such very important things necessitated that they cooperated with each other. Otherwise, for all practical purposes, Bombay, Madras, and Bengal, they were independent of each other. But after the end of dual government, this situation had to change. Bengal being more important considering its territory and revenues, the other two were made subordinate to Bengal. And therefore, in this phase of company rule, we will see the trend of Bombay and Madras being constantly subordinated to the control of Bengal. Let us now dive in and see each one of these acts more closely. Starting with Regulating Act of 1773. Although this act I have taken up in an earlier lecture also, because the context over there needed this act to be touched upon. Today, for the sake of continuity and flow, we will be taking up this act quickly once again. Also, many students join new in the lectures and therefore they don't have a background of the past lectures. Hence, it necessitates that we cover this and the Pitt's India Act also. Let's see what were the provisions, context, and consequences of Regulating Act of 1773. As the name very specifically mentions, Regulating Act, the intent is very clear. East India Company, which had enjoyed a high latitude of freedom earlier, now had to be closely regulated, lest it becomes a burden for the British government. Already people like Lord North and Edmund Burke, great politicians from Britain, thinkers, they had very harshly criticized what East India Company was doing. And therefore, the British Parliament had to respond and pass a special act. What does this act say? This act initiates British government's involvement in the affairs of India. Until this point, it was East India Company which was largely acting on its own volition. But now, for the first time, East India Company was going to be regulated by the British authorities. Secondly, this act will start the centralization of administration, that is, making Bengal more powerful, the governor of Bengal getting more and more powers and the other two getting subordinated to it. How exactly? We're going to see that in the provisions. First and foremost, Court of Directors, who were the representatives of shareholders of the company, and they naturally stood for the commercial interests of the company. Remember, the shareholders have invested their money in the company and they expect a ROI, return on investment. It is their interest, and Court of Directors are representatives of those shareholders. So they have a crucial role to play to oversee the commercial functioning of the company. But since the Court of Directors had also played a dubious role earlier, the British Parliament decides to have some control over here as well. Now the Court of Directors would have a 4-year term instead of 1 year, but in return, they would not be allowed re-election. This was done to ensure that there are no permanent vested interests that develop in the Court of Directors. Furthermore, 1/4 of them had to retire every year, much like the system that we have in Rajya Sabha, where we have retirees every 2 years. So 1/4 every year, 25% churning every year will happen. Court of Directors and British Parliament. Provisions in this context. Governor of Bengal was now dedicated as Governor General of Bengal. He was now known as Governor General of Bengal. This elevation in the nomenclature was to signify his relative importance vis-a-vis other governors of Bombay and Madras, of course. Warren Hastings was already serving as Governor of Bengal, and consequently ex officio, he now becomes Governor General of Bengal. He would be under direct control of Court of Directors because he is to ensure the commercial interests of the company are fulfilled. But at the same time, he was also required to report to the British Parliament. All the papers from the Governor General of Bengal that were coming to London to the Court of Directors were to be placed before the British Parliament also for oversight. A 5-year term technically was given for the Governor General. For the sake of executive functioning of the Governor General of Bengal, now see, functioning of any state has executive, legislative and judicial roles. Now that East India Company was no more a trading power alone, this specification was necessary. And for the sake of executive function, Governor General Executive Council was created. This would include Governor General and 4 members, and decisions in this council would be taken on the basis of majority. So to assist the Governor General and to ensure that he does not become an all-powerful dictator, there is an executive council that is sent from London. Now, one of these members was already here in India, but 3 had to be sent here so that the council could be completed. Now, in this council, there was to be a majority rule. The Governor General, just because he believed in something, could not get those things done. He had to ensure that majority in the council actually supported his view. Power to control Madras and Bombay were also extended to Bengal. Madras and Bombay were to be subordinate to Bengal. Private trade of individual employees of the company was prohibited, and so was taking bribes and gifts. This had been a great source of consternation in Britain. Back then in Britain, at least publicly, people or the government elites, they always believed in very high standards of probity. Whereas what East India Company was doing here in India was exactly the polar opposite of it. And these low moral standards displayed by the company had led to a lot of shock in London. And for this reason, they decided that private trade and accepting of bribes should be completely disallowed from here onwards, so that this rot can be removed. For the sake of legislative function, Governor General and his council could make rules and regulations. Please note, rules and regulation, not laws. The term laws is going to come much later. Rules and regulations for civil government, and this in a way was recognition of political and administrative functions that company was now going to discharge. Please understand this, guys. Britain is also recognizing that East India Company, whether we like it or not, has come to occupy a political administrative role, and it has to discharge that responsibility. For that, it has been given rule-making power. Otherwise, how would it govern such massive territories? British Parliament cannot do that. It's quite distant. It does not know the local complexities. The time required for travel was very huge. For that reason, this council was given rule-making power also. So this, guys, now shows that the structure of the British state is now evolving. That embryo is now starting to fashion into a more refined being. Lastly, for the sake of judicial functioning, a Supreme Court was to be created at Calcutta with 1 Chief Justice and 3 judges. 1 Chief Justice and 3 judges. This was to give justice to Europeans and the citizens of Calcutta. So it had a limited jurisdiction in that sense. The laws that will be applied would be European laws and not Indian laws. This was necessary in the context of several Europeans who were living there who could not be subjected to Indian laws because of unfamiliarity. So these were some of the major provisions of a Regulating Act of 1773. Now, while the intent was good, it suffered from some limitations. The foremost of this was that Governor General had no power to override his council. And the four fellows who were there in his council, most of them, three, generally, they ganged up together and they opposed Warren Hastings on many crucial decisions. There were a lot of ego clashes between some of these members, especially one Mr. Phillips and Warren Hastings. As I've told you in an earlier lecture, things went on such a downward spiral that both of them had a pistol duel at each other to finish off the story there and then. That was the level to which things had gone down. Constant deadlocks and problems occurred because of this. Next was inefficient judicial system. Although Supreme Court was created, but then how the Supreme Court would function, what would be its principles, how would it deal with other parallel courts that had been established earlier in India, all of those things led to a lot of issues in the judicial functioning also. This required some improvement. Lastly, ineffective controlling of Bombay and Madras. Despite very clear indication that Bombay and Madras had to be subordinate to Bengal, the other two presidencies had for long been used to having a lot of autonomy. And consequently, despite this act being passed, we see that Bombay will unilaterally start a war with Marathas. And this will lead to a lot of conflict between Bengal and Bombay. Warren Hastings, who has the responsibility of taking together all the British possessions, is naturally harassed by Bombay and Madras also, apart from his council members. This will make Warren Hastings very, very frustrated, and he will towards the end then resign. In context of the complaints that Warren Hastings was constantly making, the next act was passed in India, which is called as the Pitt's India Act, 1784. So this act was passed during the prime ministership of William Pitt the Younger, and therefore, because of his name, this act is known as Pitt's India Act. The entire goal of this act obviously was to remove the defects of the earlier act. Whatever problems were there in the earlier act, those had to be redressed. How did it go about? Supreme control of British government over companies' public affairs and administration was once again emphasized in this act. That British government is the ultimate authority and East India Company is only discharging its role under the oversight of the British government. It is not independent to do anything that it wills. Board of Control and Court of Directors. A new authority was created by this act called as Board of Control. Now, what had happened with the earlier act, that is Regulating Act, was that despite the intent of British Parliament to control over the company's affairs, practically it appeared to be very difficult. And therefore, the British Parliament decided to have a special body that will constantly have a vigil over the functioning of East India Company. And for that purpose, a Board of Control was created. A Board of Control was created. This Board of Control would include 6 commissioners, including 2 cabinet ministers of the British government. Apart from that, it will have some other members also, and this created a system of dual control on the Governor General. On the one hand, he is supposed to report to the Court of Directors, who represent the shareholders of the company, and on the other hand, he is supposed to report also to the Board of Control, which represents the British Parliament ultimately. Okay, so this is a system of dual control exercised on the Governor General of Bengal. Governor General and his council were subordinate to the British government. They were not independent authorities. Companies' territories in India were termed as British possessions for the first time. This is an important provision, guys. Note it down, make as many stars as you like. Companies' territories in India were now termed as British possessions in India For the first time, British government has asserted this on Indian territories. Governor General and his council, which had seen a lot of conflicts, now to resolve that, the number of members was reduced to 3 from 4 earlier. This was done to ensure that there would be more sanity in the discussions of this council. They will not end up with fighting pistol duels against each other. Now 3 means Governor General and additionally 3. So consequently, even if there is a 2-2 split, if Governor General can get even one member on his side, then in that case, his side would be considered as victorious. The British government also now claimed for itself right to recall any official of the East India Company back to Britain. Now, the appointments of officials of the East India Company was done by the Court of Directors. And this was a special privilege back then. They used to appoint people who were close to them, their favorites, family members, so on and so forth. Very often, it also involved some element of, bribe and corruption also. So that privilege of appointment was guarded very closely by the East India Company's directors. But in case of recall, the British government said that we have the right to recall any employee back from India. This was done to ensure more control on the functioning of EIC. Even the Governor General could be recalled back to Britain. So appointment can be done by the directors of the company. They have the privilege for doing that. But when it comes to recall, the British government has reserved that right for themselves. So those were the provisions of the Pitt's India Act 1784. Now the defects of the Act: conflicting management. The Governor General is now subjected to not one but 2 authorities. He has to satisfy Court of Directors who want more of revenue, more of financial gain, whereas there is also a Board of Control of the British Parliament which wants more probity, which wants a more effective governance and rule in India. So he has to satisfy these 2 separate authorities. Naturally, priorities of these 2 are different. So Governor General will be split between these 2. Then lack of information. Although the Board of Control was created, but nevertheless, the British government used to not get the information from East India Company on a regular basis, because of which effective control could not be maintained on the company's functioning. Guys, before we go ahead and see the next act, let me quickly make an announcement for all of you. Those of you who have missed out on enrolling on previous batches, that is P2I, Prelims to Interview batches of StudyIQ IAS, here is a great opportunity for you. Now we have once again announced a new batch, that is September evening batch, starting from 22nd September, that is tomorrow. This is going to be an evening batch which will run at 6 to 9 in the evening. A lot of you students had missed out on earlier batches. Because of public demand, one more new batch has been announced, and now you can avail this opportunity and enroll in the September batch, evening batch of StudyIQ IAS P2I, Prelims to Interview. This batch targets 2024's attempt, and it will be delivered in 3 mediums: English, Hindi as well as English. You can choose the one that suits you the best. Let me tell you guys, this is a one-stop solution for all your preparation needs. This batch, with its live classroom teaching, where you interact with senior experienced faculties, get your doubts redressed there and then, a lot of copious study material, books, test series, mentoring, and a lot many benefits, is the ideal package for you to prepare for UPSC 2024. I would urge you to make the most of this opportunity, because this is really high time, guys. If 2024 is your target, then you can't delay it any further. Winners are differentiated by their decision-making ability. Take a quick decision, enroll for this batch, and use my code JDLive for this. Using my code JDLive, you can get a handsome discount on the course fee. All right. Now let us go ahead and discuss the next act, that is Charter Act of 1793. Now, what is meant by charter? What is a charter? A charter is an official document which very clearly delineates the rights, responsibilities, limitations of an entity. So when charter is issued to East India Company, it is very specifically detailing what East India Company can do and it cannot. So the do's and don'ts of EIC were specifically spelled out in these charter acts. By the way, the Regulating Act of 1773 is also a charter act only, but since its nature was quite unprecedented, that is why it is called as Regulating Act. Let us now get into Charter Act of 1793. East India Company's charter, that is the right to trade with East that it had got, was now renewed for 20 years. So it has a probation sort of period of 20 years, after which it will be reviewed whether EIC should be allowed to continue further or no. Key provisions of the Act. More powers were given to Governor General. In my last lecture, I had told you guys that Lord Cornwallis, before accepting office, had laid out certain stipulations, conditions. He did not want a scene like that happened in Warren Hastings' times. He wanted clear command and authority over the council for important decisions. And he was given that through a special act in 1786. Now that special provision has been incorporated in the Charter Act itself. So the Governor General could disregard majority in the council so that he can take effective decisions. In special cases, he can disregard the majority. Further, he was given express and extensive powers over Madras and Bombay. Even after the earlier act, Madras and Bombay had continued to defy the Governor General at times. To avoid that, he is given extensive powers over the two. He was superseded over the governors of Bombay and Madras, and therefore he could now effectively deal with the whole of British possessions here. Now, regarding the company, trading monopoly of the company was continued, but with a rider of 20 years. After 20 years, there would be a review of this. In return, the company had to pay 5 lakh British pounds annually to the British government. So this charter, the special, status that the company has, it is not for free. It has to pay the British government annually 5 lakh British pounds. Remember that? Furthermore, the company had the right to give licenses to individuals and employees for privilege or country trade. Let us understand this. In the previous act, we had seen that private trade had been banned. Now, this led to a lot of complaints by companies officials that there should not be a blanket ban on such trade. So, relenting, so to speak, the company was given the right to issue licenses to some individuals for the sake of such trade. That trade was called as privilege or country trade. Only those individuals or employees who had the license from the East India Company could do it, and this was not for every employee of the company. Unlike earlier, where almost everybody was doing private trade. The Governor General, governors and Commander-in-Chief needed royal approval to be appointed. Now, we have discussed the privilege of appointment. The Court of Directors enjoyed this privilege of appointment of officials of East India Company. That privilege continues, but in case of important officials like Governor General, governors of provinces, and Commander-in-Chief, royal approval had to be taken. Company will decide the name, but approval will be taken from the Crown. After this, the salaries of the staff of Board of Control, this authority which was established in Pitt's India Act. Board of Control, which had 6 commissioners, including 2 cabinet ministers. Their salaries were now charged to the company. That is, company's revenues will bear the salary of these people, not the British government. Now see, this is so unfair. Revenue from India, technically speaking, should be spent over here. But for the sake of effective control of British government over EIC, the Board of Control was created and their salary is going to be paid by East India Company only. Separation of revenue and judiciary functions. Lord Cornwallis had wisely understood the need for separation or differentiation between different functions of the state. And for that reason, he had taken some steps also. We have seen that in previous class. Now, those steps had now been sanctified through the Charter Act of 1793. The revenue and judicial functions were now to be separate. Therefore, we see reorganization and redefinition of courts. Supreme Court's jurisdiction was also enhanced. Now, all Europeans living there in British possessions, they were subjected to Supreme Court's jurisdiction. Furthermore, all government employees in their official capacity, whatever they did, all of that was also subject to scrutiny of the court. This scrutiny had existed earlier, but Warren Hastings had got it rescinded. Now that scrutiny was brought back and anybody could be tried for their official functioning. All the political and administrative functions of the company would be on behalf of the British government. Remember, in the earlier act, they called the Indian possessions as British possessions. Not the company's possessions, but British possessions. Now further they are stating political and administrative functions. Commercial belongs to the company. Commercial function is of the company. But whatever political and administrative function they are doing it on behalf of the British government. So I hope you can appreciate the trend, guys, of how the British government's control, the Parliament's control on EIC's functioning is increasing. This brings us to the next act, which is Charter Act of 1813. Let us see its provisions. Context of the Charter Act is very crucial, guys. We have to know that in the background in England, Industrial Revolution has advanced tremendously. England is leading now in terms of industrial production, and in fact, others are just starting to catch up. And consequently, there is a new capitalist lobby in England. This new capitalist lobby is extremely jealous of East India Company's monopoly and privileges. This capitalist lobby is constantly pressurizing the British government to actually do away with the privileges of East India Company. Furthermore, Napoleon's rise just before this Charter Act. In 1799, Napoleon had assumed power as the first consul in France. Subsequently, in 1804, Napoleon had also become the Emperor of France. Now, after becoming the Emperor, he wanted to subdue the British, and for that reason, he started the continental system. Because he could not militarily defeat the British, he developed an economic blockade system of Britain, which was called as the continental system. British ships were prohibited from coming to the coast of Europe and trading their goods there. This naturally created a lot of pressure on the British industries. The British industrialists were now, hounding the British government to at least open up the trade with India so that they could deal with the challenge of Napoleon's continental system. Furthermore, ideas of liberalism. Guys, capitalism is basically, a manifestation of that liberalism only. It's you can say an economic side of liberalism, and liberalism prioritizes individuals' freedom. Now, by giving a special monopoly to East India Company, naturally individual freedom of others was being compromised. So with the rise of liberalism in 19th century, we will see that the concept of monopoly will become outdated and people will want more fair and open competition. Similarly, the ideas of utilitarianism was also on the rise. Utilitarianism necessitated that the Britishers do not limit their role only for the sake of their interest. Instead, they tried to bring about the benefits of Western civilization to India. And consequently, there will be demands for certain opening up of reforms in India also. Demands from Christian missionaries had also been rising to allow access to India. Thus far, the British had not allowed Christian missionaries to come to India and preach. They knew that Indians were finicky about their religious practices, and this can lead to conflicts. Furthermore, many of the early company officials were also Indophiles, and they did not want to change Indians as such. They very often had a lot of regard for India's civilizational history also. But now all of that is set to change. Charter Act of 1813 will come in this context. Now let us see, guys, what were the provisions of Charter Act of 1813. Commercial monopoly of East India Company was ended by Charter Act of 1813. Market economy will now be promoted. Provisions will be made for education, allowing of Christian missionaries, so on and so forth. Let us see the provisions individually. First and foremost, in context of trade, what do we see? Company's monopoly was ended, except for two. One, trade with China and trade in tea. Except in these two areas, company's monopoly was ended, and now any Britisher, private trader or company could trade, in the East. Except in two areas, trade with China and tea trade. Now, since these two were very powerful and lucrative trades, the exclusivity was still maintained in Charter Act of 1813, but rest all was open to all British merchants or companies. For the sake of education, 1 lakh rupees was to be set aside from India's revenues for educating the natives. 1 lakh rupees. Now, 1 lakh rupees was a very paltry amount even back then, considering that it was for the education of whole of British provinces. Back then also, British had substantial presence in India. But at least the first step was taken, and we have to locate this in the context of utilitarianism, liberalism. These ideas in Europe had compelled the British Parliament to make some provisions for education also. Third, in terms of constitutional development, for the first time, British territories in India were defined. What are the British territories? These were specifically defined in a British Parliament's Act. So now see, guys, how the control is increasing. First, they called possessions in India as British possessions. Then in the last act of 1793, they said that the East India Company's political and administrative functioning is being done on behalf of British government. And now thirdly, for the first time, British possessions have been defined. Whatever regulations were made by the three presidencies, Calcutta, Bombay and Madras, those had to be placed before the British Parliament also. Missionaries were now allowed to come and preach in India, and we'll see a steady flow of missionaries who will set up schools, colleges, hospitals, and also sometimes in that process, there will be conversions too. Territorial possessions. Company allowed to have them for another 20 years. So, company's role in India was now extended for another 20 years, after which a call will be taken. So company is constantly kept on a tight leash. It is not allowed to become complacent. If you don't behave well in the next 20 years, then all of this can end, is the message over here. Okay. Now, Charter Act of 1813, guys, is qualitatively a different act, as you can see from the provisions. And from UPSC perspective also, guys, this act has seen the maximum number of questions over the recent years. Therefore, be very thorough with the provisions of Charter Act of 1813. Now, why is this act so significant in that time? You can understand that by changing nature of British rule. Before 1813 and after Charter Act of 1813, you will see there will be a significant change. What has changed? See, earlier British interest in India was fairly narrow. They wanted to eliminate European competitors. The French were fighting. The Dutch also did try. The Portuguese had long been subdued, but then the threat was always there. So in this manner, the primary objective of East India companies was to overcome the threat of European companies. The goal was to control financial resources through taxation. Through revenue mobilization, controlling of financial resources is the goal. But after Charter Act of 1813, when Britain has also transformed as a modern industrial society, what do we see? The goal changes. Now the goal is more about market for manufactured industrial goods. So this is more like mercantile phase, and here we have more of industrial phase. Naturally, since the phase has changed, the interest have also changed. Now it is more about market and supply of raw materials. That is what is the primary interest. Consequently, the nature of British administration will also be different. Earlier British administration did not do much of change when it came to judicial system, nor did it pass any modern laws to regulate economic transactions. But after this, we'll see there will be a complete overhaul of legal structure in India. Why do they need to change legal structure in India? Because to meet these things, to ensure that India is a supplier of raw material and a source for market, they need to overhaul the legal structure over here in India so that British commercial relations interest could be promoted. Okay. For this purpose, Indian administration and judiciary will be transformed with the help of modern laws so that they can facilitate this. The, commercial or economic interest of British, that is raw material and markets. So 1813 in that sense is a very important threshold in terms of constitutional development in India. After this comes the next act, that is Charter Act of 1833. 1813, 20 years timeline was given. Naturally, 20 years later in 1833, a new act was necessary. This act is also called as St. Helena Act of 1833. Now, why is it called St. Helena Act? Quickly, I'll just mention that story to you. St. Helena was, or rather is, an island in the Atlantic. Now, this island was first discovered by the Portuguese and then later occupied by the English. This was the stopping point or pit stop for ships which started from England en route to India. South Africa also for that matter. So they used to always halt at St. Helena. It was a convenient place for them to wait for a few days, refurbish, refuel, and then start their onwards journey towards England. It was a very important strategic place. With Charter Act of 1833, this St. Helena Island was taken back from East India Company. Some compensation was paid, but St. Helena now belonged to British government and not to East India Company. That is why also it is called as St. Helena Act. Since a lot of students have curiosity why it is called so, that is why I just mentioned it. In Indian context, that is not relevant. End of trade monopoly of East India Company. Now, whatever limited monopoly it had in terms of trade with China and tea trade, these two were also ended by Charter Act of 1833. Free economy will be fostered here with India. Anybody can come and freely trade. Any British merchant or company can freely trade. Codification of modern laws will start. Now the Britishers require a more robust legal administrative system. And for that reason, codification was essential. So codification of laws will start in this process. Laws will be modernized to suit the commercial interest of the British. You'll understand this as we see the provisions. Let us see the provisions one by one. Number one, governance now would be in the name of British Crown directly. So once again, you can see that increasing control, emphasis on control by the British government. Crown is now ruling. Okay. Government has not been taken over, but it is being done in the name of the crown. In terms of trade, the earlier monopolies have been ended. China and tea is now over. Third, Governor General of Bengal. You remember this designation was created by Regulating Act 1773. Now this has been further changed to Governor General of India. So this is centralization, okay, this which we just spoke earlier, centralization of power. Governor General of Bengal has now been designated as Governor General of India. It was logical because now the Britishers had defeated Marathas. 1817, Marathas are defeated. And with that, the whole of Indian subcontinent except Punjab and Sindh are in their kitty. And consequently, it made sense to have a designation like this, Governor General of India. Before that, since Marathas occupied a huge swath of land in western Maharashtra, Gujarat, central India, northern plains, Rajputana, therefore the Britishers could not rightly claim any such high-sounding title. But now it was logical. Okay. Complete control over revenue and expenditure of India. Who? Governor General will have this control. Governor General will be given the full authority about revenue and expenditure in India. He is given the task to maximize the revenue, to streamline the expenditure so that the company's commercial interests are not suffering. Bombay, Bengal and Madras and other regions were all subjected to control of Governor General of India. And now it's very clear he governs over the whole of India. Naturally, all provinces come under him. Bombay and Madras, this is a crucial provision. Bombay and Madras were deprived of their legislative powers. Legislative powers of Bombay and Madras were now finished. This is that increasing centralization. Earlier, Bombay and Madras were subordinated, first in matters of war and peace, then on all issues. Now, even their law-making power has been stopped, and instead, they will have to abide by whatever rules, regulations are made in Bengal. A fourth presidency was created at Agra, but then it was later suspended. So just a fact you may remember that Agra presidency was created. So now see, look at things geographically. They have Calcutta in the east, Madras in the south, and Bombay in the western area. But then they don't have anything in north. As in, territory is there, but a strong administrative presence. And for that reason, Agra was considered suitable. So a presidency was created there, but then it was disbanded later. All right. Some more provisions. Law Commission of India. Charter Act of 1833. It created a new position. Governor General in Council would now have one more member called as the law member. Now this guy or this council had to legislate for whole of British territories. Naturally, this required a lot more expertise. For that reason, an expert member, a law member, would be added to his executive council. He'll not be a full member. He does not have right to vote, but he is there to assist in this legislative functioning. Lord Macaulay, Lord Thomas Babington Macaulay, very legendary British official of that time. He will become the first law member. Codification of laws was also to be done under this same law member. Codification of laws. The idea of codes was implemented successfully in Europe by Napoleon. While Napoleon is remembered for his great military victories, what a lot of people do not know that he was a great administrator also. Perhaps he was greater as an administrator than as a military personnel. And one of his brilliant ideas was codification of laws. This idea was later emulated by countries across the world. And here in India, the British started codification in 1833, and out of this will be born later Indian Penal Code, Criminal Procedure Code, Civil Procedure Code, which all are created around the 1860, 1859, 60, 61, in that period. All of this will be created. That was a provision under Charter Act of 1833. The law member did not have right to vote. He is not a full member. He can participate but not vote. Laws were to be called as acts. Now for the first time, laws that are being created will be called as acts. Before this, they were called as rules and regulations. Earlier, they were called regulations. A very crucial and landmark measure of this act was induction of Indians in government service. The act very clearly said that there would be no discrimination based on religion, color, birth, descent, etc. while recruiting in the service of East India Company. It was to foster open competition for civil services. This was the first time that something of this sort was being articulated by the British. Now, you remember the earlier Governor Generals like Cornwallis? They had forbidden Indians from important positions. Racist-minded Governor Generals were there earlier. But at this time, it is William Bentinck, the reform-minded Benthamite. Okay, he was a follower of Jeremy Bentham. So he was the Governor General at this point, and his influence is visible. Perhaps this measure allowing Indians in government service was also on account of the kind of you can say sympathy that he had for people in India. Later, this idea was dropped, and it will be another 20 years when it will be taken up in the next Charter Act. But at least something of that sort was mentioned. Then the provision of slavery. The Act specifically mentioned that condition of slaves must be improved. And finally, practice of slavery must be abolished, which it was done in 1843. Guys, this part of British history, parallelly, there in Britain, is a very crucial part where we see the rise of idea of liberalism, individual rights and freedoms. The famous Reform Act of 1832 was passed in Britain around this same time. That is really like the crescendo of idea of liberalism till that point. And consequently, we see in 1833, the British banned slavery, across their colonies. Similarly, in India also, it will get banned in 1843. Okay. USA will have to fight a civil war to end it, but in case of India, it was ended in 1843 itself. All right. So now, what is the significance of this act? The role of East India Company as a commercial body comes to an end. Okay. Why? Because the monopoly has been completely abolished. Now it is purely administrative body, and territories that it possesses are being governed in the name of the crown. So role of EIC has now changed completely. Governor General of Bengal is now Governor General of India, and William Bentinck, who was already there in the office, naturally he got this elevated status. So he was last Governor General of Bengal as well as first Governor General of India. Provisions to get Indians into administration was another significant one, but then this hardly happened. Practically, there were a lot of hindrances and Indians did not actually enter the service in any significant way. Then separation of legislative and executive functions. Governor General in Council had distinct roles of executive as well as legislature. And this was acknowledged by the induction of the law member and giving the Governor General and his council a right to legislate for whole of India. So now guys, you can see that there is evolution in the polity of East India Company. Very clearly, the roles of executive and legislature are being demarcated and understood as separate. We have based our constitution on certain principles that have evolved through this long history. Lastly comes the Charter Act of 1853. Let us see the Charter Act of 1853, the last one in the history of EIC in India. No limit now was given, unlike earlier times when there used to be 20 years time given to EIC. This time round, nothing of that sort was mentioned in the Charter Act of 1853. During the time of Lord Dalhousie, the famous Governor General of India, this particular act has come about. Let us see its provisions. Court of Directors. Number of directors was now reduced from 24 to 18. British Parliament reduced the number of directors. Furthermore, 6 were to be appointed by the British Crown itself. So you can see now the company's days are only numbered because inside the commercial functioning of the company also the British Crown has a say. 6 of these members were to be appointed by the Crown. The Court of Directors could create new presidency or province as required. Now, since the British dominion in India had expanded tremendously and there were several new areas that were incorporated, and for the sake of administration these were very huge and unwieldy. Therefore, the right was given to create new provinces and presidencies. Which ones were created? Separate governor was appointed for Bengal presidency. Until this point, Governor General of India was parallelly also responsible for Bengal. So he is looking at the whole of India, but also like earlier times he has to deal with Bengal also, which overburdened him. And consequently now a new governor was appointed for Bengal, so that Governor General of India would be relieved from the functioning regarding Bengal and he would focus on the overall scene. Sindh and Punjab were added in this process. Before this act, we see Sindh was taken over in 1843 and then towards the end, Punjab was also taken up. Now naturally, since these two territories are added, some changes will be required. So a lieutenant governor was created for Punjab to govern over Punjab. Assam, Burma and central provinces, these were separately created as provinces, separate provinces, like it was mentioned here in this act. Expansion of Governor General's office. Law member which came in the previous act, he was not a full member. He did not have right to vote. But with this act, he was made a full member with a right to vote also. Governor General and his Legislative Council. So there is Governor General's Executive Council for executive functioning, that is government running of the day-to-day running of the government. But apart from that, there will be Governor General's Legislative Council, which will have membership of which was increased from 6 to 12. There will be 12 members in this council who will be doing the law making related business. Separation of executive and legislature. So now we have a separate Governor General's Executive Council and a completely different Legislative Council. Although yes, the executive members are also there in legislature, much like what we have in a parliament. The Prime Minister and Council of Ministers, they are part of the parliamentary system only. Unlike in USA, there is strict separation there. Here in India, in parliamentary system, we have a fused kind of a idea. The same thing can be visible here. There is a Governor General's Executive Council, and then there is a larger Legislative Council, which includes the executive members also. Okay. So local representation in Indian legislature was now started. Governor General's Legislative Council will have representation from the provinces also, so that their interests are also represented in the Central Legislative Council. Thus was born the concept of ILC or Indian Legislative Council. Whatever laws were passed over here, they required the assent of Governor General, without which they would not be considered as acts. And also he had the veto power to shoot down any law that was passed by the council. All right. Now, who were the members of the Legislative Council, Governor General's Legislative Council? It included Governor General, Commander-in-Chief, members of Governor General's Council. You remember these were 4. First, we had in Regulating Act 1773, we had 4 members. And then in Pitt's India Act, it was reduced to 3. And then in Charter Act of 1833, again 1 law member was added. So that is 4, constant at 4. So those 4 are also there over here. Plus we have 1 Chief Justice and 1 regular judge of the Supreme Court and 4 representative members from company servants with minimum 10 years experience. Company servants with 10 years experience. They would come from Bengal, Madras, Bombay, and northwestern provinces. From different areas of British India, these 4 members will be arriving, and together all of these, they form the Legislative Council. I hope you got this, guys. Okay. Now, towards the end, let us see some of the significant points of Charter Act of 1853. Why was it important? Origin of Indian Civil Services, ICS. Earlier, the company had the right of patronage, which means they would appoint the civil servants of East India Company. Now, that was completely removed, and instead, Charter Act of 1853 spoke about open competition based on merit. Open competition based on merit. This would be open to all, including Indians. So this is the point where, guys, actually the process becomes, at least, legally speaking, accessible for Indians. Practically, there were many hindrances. That's a different story altogether. But for the sake of argument, at least we can say that yes, from this point on, the system became open for Indians. What is the importance of this act? Number 1, separation of legislative and executive functions. So Executive Council, when it is working as executive, it has those limited number of members. They're doing that executive work only. And then separately, we have a Legislative Council, which is a much larger body, and they are functioning only regarding making laws. So this strict segregation of executive and legislative functions was introduced in Charter Act of 1833. Okay. Now, this legislative wing of Governor General's Council, it acted like a parliament, much like what we have in Britain, much like what we have evolved on a greater scale later. Essentially, the structure, the basic idea is the same. Birth of civil services. As we discussed here in this point, Charter Act of 1853 is the starting point of Indian civil services. Local representation in Legislative Council. Those 4 members who were coming from different provinces, that started the practice of local representation in legislature. For the first time, while making acts, we had representation from different areas which would contribute in making those acts. Earlier, whatever happened there in Bengal was made applicable to Bombay, Madras, and other areas, but not now. Now there was some sense of local representation. And lastly, relief for Governor General of India, as he was relieved from the functioning of Bengal. Now he could devote all his time on functioning as Governor General of India alone. These guys were some of the important acts that were passed during this period. This area is a priority area when it comes to prelims, and as you can understand, there are a lot of provisions on which MCQs can be framed, and they are framed every year. So prepare these areas very well. I'll see you in my next class, where we are going to see some key economic policies and revenue policies of East India Company. I'll see you in my next class. Thank you very much for joining today. Do like this video, share it with your friends, and leave some love in the comment box. Take care, all of you.